Mute. Good evening to all the students of the SLW 616 and SLW 646. You are welcome to my class today, and I am dealing the PIF-IRAC model or Iraq model. When the case briefing is concerned, you have to do in the PIF-IRAC model. When problem question is given, in other words, facts are given, at that instance, you have to solve that problem question in IRAC method or formula or structure. That is the thing which I told you. It is the universal way of solving in such a manner. Now let us see the work of, why it is so short, I don't know. I want to magnify it. Yeah. Yes. Now I would like to magnify it, the work of the Kitenge and who sent to me for, yes, this is the work. Yeah, Karbusana Hamis Ahmed, you are waiting on the, I say yes. No, not this one. I want to maximize it. Yeah, this way. Right. Is it visible? Say yes.
Yes, Professor, yes.
Yeah. Actually, it is the what the work which I have given you is, I will give the problem. In the word means I will give the facts, and you have to solve in the IRAC model. When you say IRAC model, this procedure will not come. When you want, I have given the judgment to you. At that instance, PIF-IRAC model. That is case briefing. And when the problem is given, which is nothing but the facts are given, at that instance you have to do in IRAC model. And these facts which you have made it here, I will give in the question paper. And you have to start from issue. Is it clear?
Clear, Prof.
Very good, very good. See, I give the model here, and this is briefing a case. In the briefing a case, procedure will come first. Next, the title of the case law comes with the citation, and who are the people who decided the case in that court. Their names are there. Here, these are the names. And later on, the pre-trial, what happened, or head note, or the gist of the case law. At that instance, you have to write whether it is an appeal case or whether it is a original jurisdiction case. For instance, you take the Smith versus Baker. This is an appeal from the Supreme Court to the House of Lords, whereby the plaintiff employee sued his employer for the negligence. That is the issue number 1 involved over there, and which resulted the injury to the plaintiff, and with that injury, and he wants to file a case against the defendant for the compensation, and the defendant has taken the plea of voluntary not fit injuria, but failed to plead the defense, and hence the appeal was dismissed. It is the pre-trial version. When the appeal was dismissed and he approached this court, see here I told you in the facts, the favor of the plaintiff, hence this appeal into this court. What court? Is the House of Lords court. So the facts I will give in general. in the examination. And what you have to do is you have to write in IRAC model. That means that is the style of solving the problem question. So the facts are already here, and now you have to do how to write the IRAC. When you come to the issues, yes, always I told you whether the issue is number 1 or number 2, whether the issues are 2 or 1. So generally the issue is not 1 in any case. The reason is there was a breach of a contract by inducement. Okay. You need not to write whether there was a breach of a contract by inducement or that there was a breach of a contract by inducement of the third party. And is it only the issue? What is your plea? Kitange. Yes, it is the inducement of the breach of a contract. Let you presume it. Then what is your plea? Prayer.
Then, Prof.
The prayer of your is, if a person has made a breach of a contract by the inducement of the third party, then the person who were in the contract and who was injured by the breaching of this contract can bring an action against the third party who induced one of the party member and where he or she breached for the damages. So what is your prayer? Number 1, either you can ask for the specific performance or you can ask for the damages. But when you say the specific performance, even the person who is a party to your contract may deny also. So in all the cases, you cannot ask for the specific performance of the contract. What you can ask is, you need not write the question mark here, and you can write the semicolon. The second issue is, what is the second issue? The plaintiff is going to get any damages or not, or the defendant will be, whether the defendant is or was liable for the breach of contract to pay the damages to the plaintiff. Tosha. Is it clear?
Clear, Prof.
Here the defendant means the person who induced one of the party. And that for the third person is a defendant. No doubt he is not liable under the contract, but he is liable under the say I don't know or pass on.
Economic authority.
Repeat.
Economic authority.
No. The
Prof,
point is
clear about the
here,
question.
though he is not a party to the contract,
Right.
but he can be sued under the inducement, and which is nothing but the negligence. Negligence is nothing but tort.
Gotcha.
He can be sued under the tort. So, for the negligence which he made it for the compensation, for the damages. So, the defendant was liable for the breach of the contract to pay the damages to the plaintiff. Is the another point for your plea. So, the rule is, and I don't know whether you have seen the original case law, that is Allen versus Flood. Allen versus Food or Flood. Kitenge. Is it a food?
Suddenly, is it
Okay,
suddenly
let me
because
see Alan versus food. Let me
suddenly
see
that's
whether
food?
you are right or I am right. Eh? Alan versus
I'm
food.
right.
Yeah, it is not a food. It is a flood. So I think
Mm.
what you wrote, Kapula.
I missed.
And what is that? I said something I am not accepting. My eyes are not accepting that word. I say, what?
Mm.
Something was
But
there. I felt it when I saw it. So Allen versus Flat is the right case law. And here we have to read the full version of the case law. Allen versus Flood,
flood.
the full version of the case law we have to read it. So for that
Mm.
regard, should write Allen versus Flood, the full judgment. So when you read the full judgment of the Allen versus Flood, it will give what are the pursuing cases to support the stand of the issues to get the compensation in that regard. And we could know it. Like I don't know, today the internet is very slow, it seems. Okay, let me see at least teachers net. But they cannot give the more cases there. They give only the brief. Like this is a tort, it is a damages, interference with the trade, there is a malice, there is the intent to injure, and motive also there. See, these are all the elements are present over there. So if you want, you can make it whether there is a malice is there or not, or whether there is an intent to injure the person is there or not. But overall, the result is made a breach of a contract. That means interference with the trade or interference with the contract. The flood and Walter was a shipwrights employed in the ship. Of course, here I give this one in the examination. That is nothing but the facts of the case law. So here, maliciously inducing a breach of a contract, and the issues is whether the judge here in finding the Allen had induced the procurement of the contract unlawfully. He made only one issue. But what about the compensation? Of course, here he head he has given, that is the head is nothing but the conclusion. But where is the analysis? Analysis, you have to see it. What are the supporting case law for the issues that you want to raise it? And you have to support the case law, and you can say that, yes, with this regard, the inducement of the breach of a contract, and the person would be held liable because the other party got injured because of his non-performance of the contract of one of the party. So either he can file independently or he can file jointly also. The both the people, those who induced and those was induced by. So these are the two people there we can make it out. But I said Alan versus, yes, somebody kept it open there. Fidel Kitenge, you did not mute it. Kitenge, mute. Yes, now very good. Otherwise, I am getting the voice from your house. So, in the Allen versus Red, justice has given, but I want to see the full case law. That is my point. Let us see the Allen versus Red, another case law that what is given in that. If you happen to see the full case law, yes, here you could see the full case law. I don't know whether you read this full case law or not, because Allen versus Flood and another is the full case law, and it will give that what are the continued reading request you trial. Okay, no trial because we want to make it out. So what are the cases should be there? Supporting cases. How the case is decided in total manner. So Indian Qanun, it is a Indian. Of course, Indian Qanun has given wherever there is relevant cases are there, Allen versus Flood, they have mentioned here. But if you had to see the total case law, they definitely only we don't need the case summary because case summary gives only the a little facts only. And let us see that whether this was as given the full case law. Right to reputation, right of the bodily safety and freedom. And I want to know what are the supporting case laws are there. Citations, Allen versus Flat, name of the case law, judges in the case, Lord Hawkesbury, LC, Lord Watson, and background of the case. Generally, I will give and judgment. When you give the judgment, we would like to see what are the supporting case laws are there. That is very important. But in my earlier classes, I told you what are the supporting case laws. What are the supporting case laws? Yes. In my earlier class, means yesterday class, I already dealt the supporting case laws. Forget. Number one,
Mm.
Rooks versus Bernard. Number two, Lumley versus Gay.
This guy. Yes,
Number
prof.
three, Renner versus Fletcher.
Mm.
Number
Rayland
four,
versus Fletcher.
I have given the cases. These are all having the same nature of the cases. See, here I did not find any case law here because at least two or three case law that you have to support it to your stand, and that is the reason I told you to read the original case law so that you could know what are the cases are there. For instance, today, not today, yesterday, I have given the case law for the students of advanced legal theory. I will show you what the case law I have given because the exam is already over. So I can show you the case law which I have given here for them. And this is the 600 and this is the question paper. And the case law which I have given them is, see, this is the instructions. It's a common to each and everybody. And next, it is a case briefing, PIFIRAC method, the Charles Lala versus Abdullah Mangi, that is the case law which I asked, and see the Annexer 1. So, if you see the Annexer 1, and it is given Charles case law, CHARAL, Charles case law. Yeah, this is a case law which I have given. Annexer 1. See, if this case law concern, I have given the title of the case law with the citation and quorum Malasunya judge and he decided the case law. And from there we can find the facts. See, the cases which are referred in this case law is, here it is given. Francis, son of Moijage versus Boniface, son of Kabalemeza. Kabale Meza HCD, and Magvi, son of Kimito, versus Gibano, son of Varema, Monza civil appeal, unreported case. It is another case law. And Harriman versus Smith, 1938, appellant court, that is a 305, another case law. T.O. Elias, in his book, he has given the book also. Yes, you can cite the book, experts from there, the nature of the African customary law application 130 to 131. And the Marcel Kisiu versus Timoth, son of Musuta Dodoma, there is a civil appeal case law. And Vaisariki Kare versus Baraki, another case law. And Festo versus Mokabana, another case law. Maurice Sasavata versus Matthias Maleko is another case law. See, these are all the case laws are supporting case law for this case law. Is it clear?
Yeah. Then yes, clear, prof. But I have a question there.
Yes.
Let's assume
Yes.
we are supposed to make a case brief from the fact that we have given there.
Yeah.
Then I have raised maybe two issues.
Yes.
Then, in case I want to support the issue raised, I'll be required to pick cases from the given facts so as to support the existing issue. Or what should I do?
Yes, that is the reason I told you. Read the original case law. When you read the original case law, there is a supporting case laws are there.
Okay. So I have to find the supporting case from the given
I have given
original
the list
case.
of the cases to you.
Yes, bro.
I have given the list of the cases to you. Those are relevant to the what we need to make the task.
Probably in what I've done, I've tried to find other cases which have the same element relevant
Yes, you
to the
can.
one which
Yes,
I've.
you can. Not necessarily you can cite those cases which are given in the judgment.
Mhm.
If you want to
But I
support
can.
it with another local case law, you can support it.
Okay.
That is the mind elaboration. That is the mind of a thinking. And you can give your opinion also in the motion. My opinion, the judgment given by the court is not appropriate according to my view. It should be given in this way because these are the factors are there which will change the judgment. That is the reason you
So
can see the ascending judgments, you can see the descending judgment, and both are right in their own perspective. But majority is the law, and hence, which judgment will prevail? Which judgment will prevail?
it depends, Prof. For instance,
Why
in
it
the case of
depends? You
Tanzania,
can say it differently. The judgment of the assenting judgment will prevail over the dissenting judgment because the bench is consisting of not even number, odd number. When the odd number is there, for instance, 3, 5, 7, 9. Could you give the 4.5, 4.5? Hapana. Either 5 or 4. If the 5 are the ascending judgment and 4 are the descending judgment, and which is prevailing over there? The number which is more in the judgment will prevail over there. Is it clear?
Yes,
yeah,
Professor.
It's simple mathematics it is. Any judgment of a controversial nature will refer to the bench. And the bench, either a division bench or full bench. Either may the full bench be 7 or 9. Even the constitutional bench may be the 11 judges. The 11 judges, among them, 6 may have given the assenting judgment and 5 of them given dissenting judgment. Which judgment will prevail? Sema. Which judgment will prevail?
Professor, please repeat the question.
Simple question. I don't know why you are not understanding. There are 11 judges are there in the bench. And 6 of them given the ascending judgment. And 5 of them given the descending judgment. Then which judgment will prevail?
The majority one.
Majority one. Which is majority one? Dissenting is the majority one and ascending is the majority one.
The descending one.
Which is more in number that will prevail.
Yep.
Is it clear?
Yep, Professor.
Suppose if the ascending judgment are 4 and descending judgments are 5, then judgment is Dissenting judgment prevail means not liable or dismissed. Is it clear?
Yeah, Professor.
Because majority is the law. If the assenting majority is more, means number is more, then that will prevail. If the dissenting is more, that will prevail. Is it clear? But in generally, assenting judgment is a positive thinking and the dissenting judgment is a negative thinking. Means approach. In approach, sometimes your approach may not be right. For instance, I will give one example. Mute, I could hear your house dialects. So now, there is a rule is there. Truth should prevail, always. Is it clear? Truth should prevail. Yes. But in certain cases, to save a person, we can say the lie also. Yes, what do you want? You ask me. You are calling someone, I could hear. That's why when you don't want to speak at the time, you unmute it. Hamis Ahmed, I did not see your microphone. Yes, now I saw your microphone. And always mute. When you want to speak, at the time you unmute. So here our study is assenting judgment and dissenting judgment, and the majority is the law, and hence we can make it out. For instance, if I give an example, in the good olden days, people doesn't have the dress. They used to go naked in the forest. Are you following me?
Yes, Prof.
Yeah, Professor.
Now, after the civilization is concerned and they became advanced over there, then at the time they used to wrap the leaves around the private parts. After some times, when it's grown over there, they try to use the clothes. Not clothes were not there, the skin hide is there. Means animal hide. Skin, they used to wear it. After some times, the textile industry has come and they are wearing now the clothes or the saris or we can say captura or whatever it may be there, suits, dress, kanga and etc. Can you go back again the naked wear? Answer is no, because we are civilized now. And hence, the civilized one will always prevail. In the golden days, that was the practice. So what is the good practice is there, and that practice should be the prevailing one. So the assenting judgment, dissenting judgment, be depending upon the prevailing situation over there, why it is made, and that we can make it out. So what I want to say is, unless until you read the original case law, and that instance only we know what is the economic efficiency would be there. Why they decided in that way. And why this case law has come over for that as an example. So, any example which I have given or we are studying is, it is having connection with the law and economics. So, the judgment which is given over there is more economic value than the other way. Merely getting the loss doesn't mean that you are suffering with the losses. No. Merely suffering the losses will not get any right to claim it. But when you got the injury, like we have studied the demnum sine injuria and injuria sine demnum. Have you studied or not? Sir, we studied very long back. We could not know, sir, what is that case law and what are the supporting case law for that regard? Anyone? Can you give me one supporting case law for injuria sine damnum or a damnum sine injuria? Don't kill the time. If you know it, you give me. If not, say pass on.
Pass on.
See, every activity of the maxim, there is a landmark cases are there. A legal injury is caused without any damage, without any economic damage. At that instance, we can say Gloucester Grammar School case law is a landmark case law. Because there is an injury, economic offense, economic damage is there, but there is no legal injuries caused by opening the another school in front of that school and keeping the less tuition fee and more infrastructure and good teachers. But when you come to the injuria sine damnum, a legal injury is caused but without any damage of finance. The landmark case law is Ashby versus White, where a person wants to use his franchise vote, but the polling officer or presiding officer did not allow him to do so because he's having the old voter list, but he is already a voter and he last year also that he used the franchise, but he said, to whom that I would like to vote, even though he won with the bumper majority, but still a legal injury is caused to me and hence you have to pay the compensation. So nominal damages are awarded. In the Act of God, what is the landmark case law in the Act of God? Vis major or the civil law terminology, force majeure. If you know it, you tell me. If you don't know, you say pass on. Don't kill my time. Participants, what is the landmark case law in the Act of God?
Pass of proof.
Nichols versus Marshland. It is a landmark case law. So each place there is a landmark case law. And that case law one should have to remember it. Like if you read conversion, that is one of the offense in tort. And there is a landmark case law in the conversion. And there's such conversion case law that you have to make it out to read. Then only that you will be successful. So inducement for the breach of contract, there is a 3 or 4 cases are there. Allen versus Flood, Rooks versus Bernard, Lumley versus Gay. These are the famous cases would be there where the inducement of the breach is there. And the rule of you mention only Lumley versus Gay and Mughal Steamship Company. Yes, this is also a relevant case law. McGregor Go and Company and the OBG Limited versus Allen. But you can also say Rooks versus Bernard also. So these are the cases that we are supposed to make it our stand. And yeah, when you write, you should not supposed to commit any mistakes, because when the mistakes are there, it will be awaz aa rahi hai ab tak. When the mistakes are there, I could easily make it out. Then full stop should be there after V. So after V, there should be a full stop. After company, CO, C capital letter, small o, and a full stop. And the limited, L capital letter, TD, small letter, full stop. And V, after there should be a full stop. McGregor, Go and Company. When you say company, it is a abbreviation, short form. C capital letter, O, small letter, full stop. And this citation should not be in italics, it is in ordinary. Of course, it never ends with a full stop here again. So that is the rule position. I said I want to make it out back. Okay. So OBG Limited, what is the mistake that you have committed here? Can you tell me? Kitange, can you tell me what is the mistake that you have committed here?
Prof, in that case, I didn't go in detail into the case, but I just read the principle which was laid down in that case. And I found that two important elements were laid down in order to prove that there was a breach of contract by inducement. That means there must be.
I did not ask it. I asked just what is the mistake that you have committed here? That's my question. But you are giving the explanation different way.
I thought you were asking me about the course of action of the case.
See, the
So
question
the
is very
mistake
much
that
clear. What type of the mistake that you have committed, where is highlighted?
bolding or making an italic, I was supposed to write it in. Prof, help me, please.
See, the mistake you have committed, LTD, it should be written L capital letter and small td and full stop. That is the mistake. And next mistake is you have to keep the space after full stop, V full stop space. Then another mistake is after the parties always goes to the comma, then the citation will come, but the citation should not be in italics. Is it clear?
Clear, Prof. Then, Prof, I have a question there.
Yeah, please.
Because you're going to attend this question in your exam, then should we use different pen, maybe black and blue one, or we can write them by using
Whichever
same
that
ink?
you want to highlight it, it should be in the different color. Fundamental
It should be.
impression principle. Whichever that you want to highlight it should be in a different color pen. Any doubt?
No, Prof.
Different color using later on, you should not make it a bold, you should not make it underline. Is it clear?
Yeah, Prof.
Now the applications. Yes, the aforementioned authorities laid out the two important factors. Two essential or important factors would be there, prove the economic tort, and other things economic tort can be constitutive, induce the breach of contract or causing loss by unlawful means. With regard to the case in hand, it is a prudence to hold that there is economic loss and based on the facts that the act definitive cannot fit within the ambit of the two important factors and that there was no any breach of contract that happened. No, there is a breach of contract happened. Where are the supporting case laws? You read here the case laws. It is you have to write here according to the so-and-so case law. It is there the breach of contract would be there. Hence, the person who made the inducement of the contract is held liable to pay the compensation to the victim. And another case laws also give the same principle that because if any person has made the inducement of the breach of contract, at that instant, even though he is not liable under the contract, but is liable under the economic tort because the negligence aspect is there, which was held in this case law. Another case law. Yes, in this case law also it is happened like that so and so thing. So the case law in the hand having the breach would be there, and where the plaintiff suffered a loss because of the act of the inducement by the third party, and hence he would be held liable in this regard to pay the compensation. Is it clear?
Clear, Prof. Clear, Prof.
When the first issue is there, you can make it out. In the second issue, what do you say? And hence, by the above cited case law, which clearly mentioned that the person who has made the inducement contract is held liable to pay the damages to the plaintiff. Right. As far the first issue is concerned, there was an inducement of a contract where the plaintiff has suffered, and that was decided in the so-and-so case laws. And hence, the case in hand would be held liable to pay the compensation to the victim, who suffered. As far as the second issue is concerned, liability would be there, the person who made such an inducement of the contract to make a breach of a contract, and hence he would be held liable based on the above judgment given. Two issues, two paragraphs in the application. Whatever that you cited in the rules, the cases should be reflected in the application. I repeat, whatever the rules that you have cited, either the sections or the cases or the maxims or the book or the encyclopedia or the expert, and that definitely should be reflected in the application in one form, in another form, it should be appear over there. But here you wrote, yes, Lumley versus Gay case law, Mughal Steamship Company Limited case law, OBC Limited versus Allen case law, and Rooks versus Bernard case law. Let you presume it, Nichols versus Marshland case law, and all these should appear here in the body. Is it clear? Application body. In application, under the application side heading. Application is nothing but policies. Next, if the two issues are there, then two paragraphs of the conclusion. First issue conclusion and second issue conclusion. The first issue conclusion you wrote already, basing on the surrounding circumstances of the case, there is no economic tort occurred, hence the claimant are not entitled to any remedy. You made the reverse. You made the reverse. If it is given in the Allen versus Flood in that manner. If it is given in the Allen versus manner, if it is referred, yes, you are right. If it is not given in that way, then you are wrong. Now let me see that in Allen versus Lead, whether your contention is right. I did not know that because I did not read the total case law of the Allen versus Lead. Because if any case law would be there, either it may be supported one or it may be not applicable one. In the both the ways you can make it out. Because the facts given in the so-and-so case law is not the similar facts given in the case in our hand. Hence, the case law result will not be applicable to the case law which is given in our hand. So you say it is not amount to the economic tort, you said. Yes. Now, let me check it. Perhaps we may be right. If I check it in a summary, I could know it here. Here the law teacher's net summary is there. In the summary, it is held that the decision was reversed, finding that Allen had not violated the legal right of the flat. Yes, you are right. And Walter, good. There was no legal right for them to be enjoyed by the employer, and Allen had not carried out any unlawful act, had not used any unlawful means. Very good, because there is a justification. And procuring the employer's dismissal. Very nice. Allen was found to have made the representation to the employers that would be happen if they continued to the employee of the floods and water. He relied on the event of that he believed could happen, and the employers believed him. There was not a considered to be an obstruction or a disturbance of the right. It was not a procurement of the violation of any right. Yes, if there is no violation of the right, then naturally the person will not be held liable, even though there is a economic tort. Allen's conduct was not actionable. However, malicious or bad in his motive might be. If he is a malicious, if it is a bad in motive, it doesn't matter. But still, a lawful act will not become unlawful because of the bad motive. And the employees were not entitled to damages, and no interference requiring the remedy was found to exist. Yes, you are right, because there is no economic tortoise and individuals over there. Whatever the Allen is did it in a rightful manner, not an illegal manner. I can make it out. I want to sell my milk to those who comes in a proper dress to my shop. I repeat. I want to sell the milk to those who comes to my shop in a proper dress. not scanty dress. And Tangazov is put it over there. And a person came in the kaptura and he said, no, you come with that full trouser, then I will sell the milk. Can he say so or not?
Prof,
Yeah.
I think that will amount to discrimination.
No, proper dress is a discrimination.
And it depends on the culture of every society.
And
For
tomorrow
example,
you will come in the chupi.
not chupi. Chupi, that is two O's.
And you say it's my proper dress because I washed my trouser and trouser is not dry and hence chupi is dry and I came with the chupi.
Chupi is not right, but kaptula is right. Myself, I like to wear
So what is the
kaptula,
limitation? What is the limitation, you tell me?
Limitation. For instance, there is a recent scenario in Zanzibar. They are not allowed to put some sort of clothes in their shops because it is against their culture. And the limit should be in accordance with the cultural standard of every society. The limit should be within
No
the
woman
limit of
can
culture.
come without having the burnos in my shop. Every woman should have the scarf and total body will be closed with the clothes and that woman will be allowed in my shop. Not skirts. Are you following me? Can
Yes,
you go to
bro.
the court? Can you go to the court in improper dress? The first and foremost, the person who at the gate will say, get out. Come with the proper court dress. Is it clear? There is a decorum would be there for each and every activity. So, with the decorum, one cannot make it out. It is not illegal to do so. But only white man allowed in my shop is the discrimination against the people. Are you following me?
Yes, bro.
Dogs are not allowed in the supermarket. Yes, it creates a nuisance over there. If you have the dog, you keep in your car and come into the supermarket. So no pet animals are allowed. Yes. Now why I am giving this thing is you have to support your stand with your cases. That is what I want to say. And here, naturally, there is no remedy would be there because there is no economic interference happened. The reason is whatever the act he did it according to his own will. It is not against any violation of the right, and hence it can be do so. So in the same manner, whatever the loss would be there, sometimes there is no economic tort, and sometimes there is economic tort. At that instance, the person who induced it would be held liable if it is economic tort and that is not justifiable by any law prevailing over there. Are you following me?
Yes, Prof. Yes, we are
So you can
following.
use the cases which are relevant, which can use also cases to say that there is no economic tort because there is no injury at all because whatever the act done by the person is a legal act. So at that instance that you are not going to get any compensation. I don't know whether you read this case law or not. Mayor of Bradford versus Pickles case law. In the law of tort is there. In the company case law, Salmon versus Salmon case law, you know it very well. Am I right?
Yes, Prof.
At that instance, a company will start by their own family members also. Am I right?
Yes.
Of course, there is a limitation is there. The member should not less than 7 members or something like that. If it is a limited company or unlimited company, even a single person also can make a company. The latest trend with a single director. Of course, it depends upon the rules of the company, how a company will be formed, whether it's a private company or a limited company, and what company it may be there. So now you know that what are the mistake that you have committed here. You cited the cases, but it is not reflected in the
application section.
I appreciate.
Prof.
Yes.
Then another thing I would like to know, as you said earlier, will give us fact. Then in terms of the format which you are supposed to follow in the examination room,
Yes.
that means you are supposed to start with the procedure, then
No
the name
procedure.
of the
It's
case.
not a case briefing.
Then we are not supposed to write that part procedure.
You are not. I am not asking the case briefing. I am asking the problem question. A problem question should be solved always in the IRAC model.
Okay.
And the judgment will follow the PFIRAC model.
Okay, so what you are going to do is to attempt a problem question and not to make a case brief.
Yeah, case brief means the full judgment is given and you have to brief the case.